Good morning. This is your Kelso Report for Wednesday, October 19th, and I'm your host, Clark Kelso. One of the toughest issues in cases involving alleged sexual harassment in the workplace is to determine when a workplace where there are occasional references to sexual topics and a certain amount of sexually oriented banter, when that crosses the line into a workplace that imposes upon a plaintiff severe or pervasive harassment based on gender. Our legal standards on workplace harassment are violated when such conduct constitutes severe or pervasive harassment. But those standards then permit a certain amount of sexually oriented talk. So when does it go too far? Well, in Brennan v. Townsend and O'Leary Enterprises, a split panel of the 4th District held that the trial court correctly granted defendant's motion for judgment notwithstanding the verdict following a jury's verdict that the defendant had crossed the line. According to the trial court and a majority of the 4th District, the evidence fell short of that required to establish severe or pervasive harassment based on gender. The plaintiff was a 15-year employee of the defendant, an advertising agency. Now, by her own testimony, she had become very close to the owner of the agency. She considered him more than a friend and like a second father to her. Over a period of years, they discussed her personal life and relationships, including discussing her sex life. She did not testify that she found these discussions to be offensive, but they did occur. There were other employees, however, who engaged occasionally in conduct she did find offensive, such as certain behavior at agency holiday parties, although none of this conduct was directed at her. There were also a few emails that had been forwarded to her which made offensive references to some female clients. However, there was no evidence that the plaintiff was ever assaulted, subject to unwelcome physical conduct, threatened, propositioned, or subjected to explicit language directed at her or at anyone else in her presence. And absent this type of evidence, the majority of the panel held there was no basis for a finding of severe sexual harassment. Nor was there sufficient evidence of pervasive sexual harassment, since the nature, timing, frequency, and context of the incidents described to the plaintiff simply did not rise to the level of being pervasive. The incidents were only occasional over a period of years, some occurred during off-site parties, and they were not directed at the plaintiff. Now, plenty of room for disagreement about the result here. The jury saw it differently, and there was a dissent here. And the dissenting justice looked at the same record and concluded there was sufficient evidence for the jury. According to the dissent, the plaintiff, quote, went along to get along at advertising agency Townsend and O'Leary, accepting an environment where the word bitch was used almost routinely. Christmas party skits included demeaning roles for women, and female clients were referred to by disgusting epithets. She survived and even thrived professionally until the blatant sexism of this workplace was directed squarely at her, and she was referred to by an executive as the, quote, big-titted mindless one, close quote. At that point, she complained and said enough is enough, as women are permitted to do under the law. But from the moment of her complaint, the atmosphere surrounding her job changed completely, close quote. Well, as you can see, the question about where to draw the line is squarely presented here by the majority in dissenting opinions. I think this is a pretty good case for Supreme Court review. The record presents a relatively common workplace environment, and the majority in the dissent have done a nice job of painting different perspectives of whether that environment violates the law against sexual harassment. My guess is the court here will grant review, and this could become a very important decision in employment law. And now our one-liners for today under the area of health law and HIPAA. In Fossen versus Blue Cross and Blue Shield, the Ninth Circuit held that the Federal Health Insurance Portability and Accountability Act, HIPAA, preempts Montana's Little HIPAA law, which contains provisions that are essentially identical to the federal HIPAA provisions. However, because of a savings provision in HIPAA's preemption statutes, federal law does not preempt a claim for relief under a separate Montana unfair insurance practices statute, that bars insurers from engaging in unfair discrimination when charging policy premiums to similarly situated individuals. Next, we have an arbitration issue arising in the context of interstate carriage of goods. In Smallwood versus Allied Van Lines, the Ninth Circuit held that the Carmack Amendment, which prescribes the terms of interstate shipment by domestic rail and motor carriers, renders a mandatory arbitration clause unenforceable, since it is contrary to the Carmack Amendment's requirement that the shipper not be forced to select a forum for dispute resolution at the time of contracting. Instead, a shipper may be given the option of arbitration only after a dispute has arisen. This case may be one that the Supreme Court will take an interest in, given its general interest in the enforceability of arbitration clauses. We'll just have to see. Next, we have a class action decision from the state court in American Honda Motor versus Superior Court, where the Second District held that the trial court incorrectly certified a class action against Honda for alleged breach of warranty involving the alignment of the gear shift mechanism of certain Land Rovers, where the evidence showed that fewer than 800 out of 15,000 cars owned by alleged class representatives suffered from the alleged defect. In light of this evidence, the plaintiffs could not satisfy the requirement that common issues predominate over individual issues. I suppose the question here is whether the court got to the merits of the claim and got out ahead of the class determination. That at least would be the basis for seeking review. Next, civil procedure and capacity to sue. In Smith versus Simmet, the First District held that the personal representative of an Oregon estate lacks legal capacity to sue in California because his authority under California law does not extend beyond the jurisdiction of the government under which that person was invested with authority, that is, Oregon. Under California law, the Oregon representative may be able to obtain ancillary appointment by a California court that would vest him with the capacity to sue, and he must be given that opportunity. Once the representative secures that appointment, then it is clear that the personal representative may sue in California the lawyers who had represented a prior personal representative of the estate for legal malpractice. Next, we have a criminal law issue in People versus Miranda, where the Second District held that substantial evidence supported the jury's finding that a 15-year-old sexual assault victim who suffered from cerebral palsy resulting in severe communication difficulties combined with physical disabilities was mentally incapable of consenting to the sexual offenses committed upon her by the defendant. The Second District affirmed the defendant's conviction of attempted rape, oral copulation, and sexual penetration, and his sentence of 11 years in state prison. And finally, in the area of juvenile law, in In Re L.K., the Fifth District held that substantial evidence supported the juvenile court's finding that a 15-year-old violated Section 273A of the Penal Code involving child abuse likely to produce great bodily harm when the 15-year-old drove her mother's truck over a 17-month-old baby, severely injuring it. The driver did not see the baby before driving over him and therefore lacked the criminal intent necessary to violate Section 273A by driving over the baby, but then failed to notify the parents about the severity of the baby's injuries after the accident, which did constitute a violation of Section 273A. Well, that's it for today's Kelso Report. Have a great day in the law.